Okay, we're back on the record in the matter of State versus Hock. Are the parties ready to proceed with the closing arguments?
State's ready.
Yes, Your Honor.
All right. Ms. Jacobson, you may proceed.
Thank you, Your Honor. Defense counsel. Arrogance put Angee Hock here today, Your Honor. She put herself out as someone who was skilled in labor and delivery and
Go ahead.
Yeah, you are. Is it?
Go ahead. Sorry.
Okay. We're good? She put herself out as someone who was skilled in labor and delivery, and specifically breech delivery. Angee Hock sold Creighton and Emily a bill of goods and wants to hide the premise that this death was an unfortunate, tragic accident and that the Noes had a free choice to decide how to proceed with their birth. Judge, I want to talk to you first about what this case is not. I'm expecting the defense to make some arguments about midwifery law in Nebraska. This isn't about the state of midwifery law. This is not an indictment on midwifery. This is an indictment on one person who chose to put herself out as an expert and chose to give advice to Creighton and Emily that they relied on. Are we wanting to try? It really is distracting. What are we? Believed in her, and 2 to 3 minutes is precious little time to make a decision that's a matter of life and death. I think you should first consider the defendant's evidence. They played a audio recording of Emily No a couple days after the death of her daughter Vera. You need only listen to that to understand and appreciate how much Emily No believed in Angee Hock. She liked Angee Hock. She believed in everything she would say to her. She tells you in that statement that at some point there was a foot. Now that's very important because that corroborates to a degree of what Mickey Heffley talked about. And Mickey Heffley talks about not only toes, but also a cord. And as you heard from Dr. Lessman, that cord information was very, very dangerous. If that cord was coming out first, we had an absolute immediate emergency. Just feet coming out, maybe a little bit different. But we also know from the identification of a foot is that there are different kinds of breech. Singleton, breech, they're incomplete breeches. Maybe 1 foot coming down or 2 feet coming down, but that's the worst way to come down, short of the cord coming out first. But that's what Emily knew from Angee Hock. And Angee Hock said, you got 2 choices. You can go to the hospital, or we can stay home and deliver because I know how to do breech deliveries. And Emily doesn't expand on anything else that Angee told them at that time. So they waited and they labored. By Creighton's account, the 2 to 3 minutes it took Angee Hock to explain to them not only the dangers of breech birth, but to say that I can do breech birth and you can go to the hospital. The reality is she didn't explain any of the dangers. She just said I can do breech labor. And the 5 minutes then Creighton and Emily talked about what Angee told them, the woman they trusted. Then there was approximately 45 minutes more of laboring. So by that account, by that math, 53 minutes. Emily went on to say that Hock never pushes them to do anything, but she acknowledged the same thing that Creighton did, that when Sabra was breached, she said, go to the hospital. They went to the hospital because, again, they trusted her and thought she was skilled in what she did, knew she was unlicensed, but they believed and trusted her because she was telling them she knew all these things. They didn't understand how dangerous it was. And when I asked Creighton on the stand, if you knew how dangerous, what would you have done? What would you have done? And he says, I would have gone to the hospital. Creighton and Emily certainly didn't want their baby to die. Nobody wanted their baby to die. Angee Hock didn't want their baby to die. We're not here for negligent crime, or intentional crime, we're here for negligent crime. Creighton tells this court that there was no sense of emergency. No sense of emergency, but yet when you hear Dr. Lessman, when you hear Dr. Bowen, when you hear the defense expert, Dr. Ophoven, it's pretty serious if a foot's presenting. When you hear the paramedics, they knew any kind of breach. This is serious. We got to go. We got to get this woman to the hospital. We got to try and do whatever we can to save this baby. Because when a foot is presenting, you have a very, very serious problem. And Creighton and Emily didn't know that because of Angee Hock. Angee Hock further knew what kind of relationship she had with Emily. Presumably understood her post-traumatic stress disorder, that she had problems with hospitals, built a relationship with her, knew she was vulnerable. We know she was vulnerable by listening to that statement. She knew Sabra couldn't be born vaginally the first time. She was there for that, 56 hours of labor. And Emily never progressed. She had that history too, going into this. So now you've got a vaginal birth after C-section, and now you've got a breech birth. Judge, I know you know what the law is, but I want to go through every bit of it because this is important. The charge is that she negligently causes or permits a minor child to be placed in a situation that endangers her life or physical health or deprived of necessary care. This crime happened in that moment she knew Vera was coming out into the world breech. Vera's leaving the uterus, coming out in the world, a live, breathing baby. And she advised him in such a way that endangered Vera's life. Negligently refers to criminal negligence and means that a person knew or should have known the danger involved and acted recklessly. She knew or should have known. You know, Angee Hock puts herself out to be this expert in delivering babies. You saw her contracts. You saw her manifesto and the 3-ring binder that has everything about her business. And most importantly, in that manifesto, the contract that she did with the nose, she puts herself out as very knowledgeable. So this court can presume from all that she actually did understand breech birth. We know she had some training, that she did understand breech birth, but chose not to tell the nose about it. Or even more dangerous and even more reckless, if she didn't understand. If maybe she's hearing for the first time when she's hearing these doctors testify, or when her defense expert wrote the defense expert report, how dangerous this was. But the point is, she felt comfortable in telling the nose that everything's going to be all right. I know how to do a breech delivery. Recklessly means acting with respect to a material element of an offense when any person disregards a substantial and unjustifiable risk that the material element exists or will result from his or her conduct. What did Angee Hock think when she gave them these options and didn't explain those substantial and unjustifiable risks? The risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to the actor, its disregard involves a gross deviation from the standard of conduct that a law-abiding person would observe in the actor's situation. Judge, if this wasn't reckless, this court should be hard-pressed to consider a situation that is reckless and negligent child abuse. She represented to the nose that she knew what she was doing, and this could not be further from the truth. You've heard evidence just how dangerous a breech can be. The description so far, as I've already discussed a little bit, is that we have a cord and toes, and Emily says there's a foot. The fact that a cord was being identified is very troubling, Judge. You heard that from the dangers of a prolapse cord, and the idea of the cord coming out first is really the most dangerous thing that's ever going to happen. I'm not going to try to repeat what all those doctors said, and they all said it. Defense expert, Dr. Bowen, Dr. Lessman, that heightened the level of danger to Vera. At that moment and through the time that it was virtually too late to do anything, Angee Hock wasn't telling them about the dangers. Waited for Emily to go into the bathroom for quite some time, wasn't telling Creighton anymore that this is dangerous, we should seriously think about going to the doctor, just, I know how to do breech births. She did not provide appropriate care to Emily, which in turn didn't provide appropriate care to Vera. I want to talk about the contract a little bit. Judge, you've read it, but the things she says in here. I provide concrete knowledge, ancient wisdom, and current research, so women can take back their power by making fully informed choices. She promised them she would help them make fully informed choices, and she was paid for that. I will work to provide comfort and perspective to you and your partner, make suggestions as issues arrive, and assist as required. I work for you directly. She was not working for them directly that day. I don't know what she was thinking. Again, I can only imagine arrogance. I know how to deliver breech babies. You can go to the hospital, but I know how to do it. I will provide full, broad information about normal pregnancy. This was nothing but normal. When this happened, this should have been, all right, everybody, hold on a minute. We've now gone from normal. We now have a very dangerous breech situation. And she could have explained that breeches can be delivered successfully vaginally. That should have been included in that, right? If you listen to, we don't know the ethics of midwives or what Ms. Hock's ethics were, but certainly it's about giving all the choices. And one of those choices was to stay home and was to maybe try this vaginal delivery. But it's all the other stuff that put Vera in a dangerous situation, that endangered her life and physical health and ultimately led to her death. I am trained to recognize, treat, and refer potential problems before they become an issue whenever possible, and will strive to do so with our mutual observation and attention throughout each pregnancy and birth. She did not do that. I'm here as a consultant and an expert in normal birth. I do not make decisions for you. I will help you get the information necessary to make informed decisions, and I expect members to respect my advice and request. But you and the final decision makers. Creighton and Emily signed that. She expected them to respect her advice and request. Where she failed was to give them the information necessary to make that informed decision. Dr. Lessman gave you a lot of information about risk of normal childbirth, breech birth, and the ethics of medical professionalism in these situations. You know, the defense went to great lengths to inquire of Dr. Lessman what these ethics are, presumably to make the point that despite all effort to go through the informed consent information, to explain to a woman, these are your options, these are the dangers, ultimately the choice is up to the woman. And it would be an assault if the doctors were to force a cesarean section, force any kind of medical intervention to deliver a baby. And that is all true, and Dr. Lessman acknowledged that. But the irony should not be lost on this court that in those final moments, Angee Hock, who was just going to respect, this is going to be home birth, all those things, she tried to perform this episiotomy. And the state doesn't blame her for trying to do that. I'm sure that was a very desperate situation. Very desperate, because she knew what was happening. She knew Vera was suffocating. And she performed this episiotomy. And as the paramedics told you, broke a pair of scissors, gave her a second one. But again, from the defense case, Emily No's statement, Emily No tells you it was 3 scissors, and she says, I didn't really want her to do that. So Angee Hock did those things. But again, Angee Hock's not a medical professional. She maybe doesn't know those ethics. We don't know. She just was acting like she knew all these things. She was trying to fix what had went terribly wrong, and she was run the shit show when the paramedics show up. Each of you told you they thought this was some medical professional. Didn't know what, didn't know if it was a nurse or what it was, and it wasn't until well after the fact they find out it's an unlicensed midwife. And Judge, it is hard to imagine what those firefighters saw. It's really hard to imagine. Vera is born from her neck down, and they know she's suffocating. One firefighter, when asked, what did you think? And he said, oh crap. Being very honest, just oh crap. Another firefighter, how did you feel? Helpless. They recognized immediately how serious this was. Vera was suffocating. I'm expecting the defense is going to make some kind of proximate cause argument And Judge, if you take the testimony of both Dr. Bowen and Dr. Ophoven, and what I'll say about Dr. Ophoven is, Judge, she's got a really impressive record of being a pathologist and specializing in pediatric pathology. And she agreed with the things Dr. Bowen said about the cause of death. You know, to put it in simplest of layman terms and words that I can pronounce easily, is that Vera lacked oxygen to her brain, and that caused her death. Dr. Ophoven ultimately, and I'll get to it a little bit later, I think stepped out of her lane a little bit to try to give us evidence about things that she's not an expert in. But when it comes to the cause of death part, Vera died of head entrapment. Exactly when there was so much damage that her brain was not going to recover, it's hard to know. Dr. Bowen tells you maybe 5 minutes. We know that the Omaha Fire Department got there within 5 minutes to the patient's side, to Emily's side, from the time of the 911 call. Judge, we also know that at the time of the 911 call, her head wasn't entrapped yet. Because you'll remember, Mickey Heffley, and there's no reason to think that she's not giving this accurately, she comes in, and I think Creighton describes, you know, part of, she saw limbs, so he doesn't describe the neck down part. But Mickey Heffley says, Vera is out from her waist down, so just seeing legs. And she goes in to try to help, and they're helping, and Angee pretty quickly says, call 911. Mickey calls 911, gives the phone to Creighton. And so, presumably Vera's not entrapped at that point. There's still hope that Vera's going to be delivered. It is interesting, however, that suddenly Angee Hock has decided we got to call 911 when she's waist down out. What was Angee Hock expecting to see if that baby was being delivered breech? That was actually presenting the way the breech would have presented. She calls 911. By the time the paramedics get there, head is entrapped, and that's when Vera is suffocating. And Dr. Ophoven talked about some things about, well, depending on how, I'm not sure what she was trying to say, but I think, and you listened to her, but something about that cord, we don't know how cramped that cord was. Well, yeah, we do, Judge. The head was stuck. She wasn't coming out. She's pushing, she's trying to come out. It's the head, the cervix wrapped around the head and the cord. If there's no room to get out, that's as tight as it can be. It's cramped. And for the most part, I think Carol's exact words were, given the circumstances, the baby didn't look that bad when they get there. And then the baby progressively got worse. So they're going to make this, and I'll get to that in a minute, they're going to make this proximate cause argument, and I think they're going to try to argue something about hospital did something wrong, paramedics did something wrong, but the damage was happening right there. And what I'll say, Judge, I'm not suggesting you even consider this, but I just would like to point this out. Let's say, for example, that the defense gets up and makes an argument to you that's going to persuade you to believe that there was some kind of intervening factor and Vera No didn't die from what was happening there at the scene. You can find that she suffered brain injury at that point. Dr. Bowen testified to that. Nobody's refuted that. That suffocation in that amount of time is going to cause brain injury. And there are lesser includeds. You could arguably find that we proved led to serious bodily injury. Or even you could go less than that, led to some injury. I'm not asking you to do that, but the point is, everyone said Vera No died of head entrapment, and the head entrapment was a complication from the breech birth that she was advising them to go forward with. Right in the ambulance, I have to spend a little bit of time talking about this, Judge. Unfortunately, because of road construction, it took a good 15 minutes to get to the hospital. And I hope the court understood what Dr. Ophoven was doing when she was, frankly, manipulating the numbers, when she was answering the questions of defense. The ambulance arrives at the hospital at 21:59 hours. We also know that Vera was immediately delivered before she was there. How do we know that? That's what all the paramedics said. Carol gets up, and he gives basically the best description of it. I believe it was Carol, but he's talking about the stuff they did to try to continue to get Vera born. First, when they get in the ambulance, had two guys on either side of her bending up her legs to try to make more space and have her push to try to get Vera out. And it wasn't until as they approached the hospital, they tried again, and this time they had both those big, strong men pushing up her legs, and then this time Carol was at her head, kind of pulling on her to try to get some room to have Vera come out. And Vera came out just as they were pulling into the ambulance bay. Carol describes that Vera was born bluish and wasn't breathing, and they started CPR. Dr. Lessman, you will remember, she's waiting for him. 911's called in, and they know this is an emergency. They've got the whole OBGYN team, they've got the NICU team, they've got nurses. Everybody's there waiting. She's got all the equipment she might need to help deliver this baby, and so she sees that baby within arguably seconds, but at the most a minute, when that baby comes off of the ambulance, hands over to the hospital personnel. Dave Hurd is doing compressions, using his fingers to try to get life back into that baby, back into Vera, because she wasn't breathing and her heart stopped. She was effectively dead in that moment, but the hospital staff was able to bring her back. So the time on the OFD is that they arrive at 21:59, and then they take the report from the doctor, or the hospital, Exhibit 148, that reports time of birth is 21:48. Fire department was performing chest compressions upon arrival at 21:50. Vera was born 2 minutes before the hospital staff got her. To take this number, to pick and choose this 21:48 number out, and then put it with the ambulance at 21:59, and I use the word pick and choose because those were Dr. Ophoven's words. She said pick and choose. When I then, on my second question, said something like, oh, so you pick and choose, she got all defensive and said she doesn't pick and choose. Judge, those weren't my words, those were her words. And somehow, I think what they were trying to do is establish that somehow there's this intervening cause there, and this was partly the hospital's fault, partly the paramedics' fault, that Vera didn't get the appropriate care. And so that means that this crime didn't lead to Vera's death. This is where Dr. Ophoven is being very disingenuous, Judge. She wasn't staying in her lane, to use a real simple way to look at this. She's a forensic pathologist, and may well be a good one. I don't know. She was agreeing with the things Dr. Bowen said. But she was talking about baby care and APGAR scores, that we look at APGAR scores, and she never did answer that question to me appropriately. She delivered babies almost 50 years ago. She doesn't deliver babies. She got ready for her testimony, presumably by reading some of these journals. By the way, of the journals she listed she prescribes to, they aren't any journals on obstetrics and gynecology. She was putting herself out to be an expert on that, on delivering babies. I asked her about what Dr. Lessman described, that in delivering a breech baby, one thing you can do is, it takes more than one person. You might push on the mother's abdomen to help give enough force to have the baby come up. She didn't even know any of those things, but yet she's before you telling about how to respirate babies. She doesn't do that. She does autopsies on babies that are deceased. I think also the defense might be arguing maybe an argument that Vera would have passed anyway. And that's true, right? Dr. Lessman says that there's dangers in childbirth. And they could have planned a birth in the hospital, they could have planned a C-section, or they could have not planned a C-section and got to the hospital right away when the foot presented, and Vera might not have made it. That's not the standard. The would have died anyway isn't the standard, Judge. Standard is that she was placed in a situation that was a risk of causing this harm. And when those choices were made, when she presented breech, that's when the crime happened. and it did lead to death. I want to talk again a little bit about unborn child because I'm expecting that from the defense. But again, I'm expecting that the defense is going to argue that Vera No was an unborn child and thus doesn't fit under the child abuse resulting in death statute because we, of course, have alleged that Vera No is a minor child. Judge, the evidence is she is a minor child. She was being born. She was alive. We know she was alive because she was alive 2 days later. The defense, I think, is going to argue that because we now have this unborn homicide of unborn child, assault of unborn child statute in Nebraska, that the legislature has now decided that an unborn child is someone in utero. And so I think their argument is, since Vera wasn't completely born, she's an unborn child, and so we haven't charged this correctly. It defies logic to ignore this intrapartum stage. Dr. Bowen used the word intrapartum when you leave the uterus until time of birth. Her foot's presenting, so she's leaving the uterus. The legislature did account for that stage in the unborn child statute because they said, who was alive at the time of the homicidal act and died as a result thereof, whether before, during, or after birth. So they were acknowledging that during birth part wasn't in utero, wasn't the unborn child. That act had to happen during in utero, but the rest not. So that argument fails. This is probably a case of first impression on this issue. Well, I'm pretty certain it is. I think if there was a case that the Supreme Court looked at, you would have heard one of us talk about it. Perhaps someone has looked at it before in some of the lower courts. But it's clear, putting those statutes together and reading those statutes together, what the legislature meant, and we have to strictly construe what the statute is. A lot of coulda, woulda, shouldas looking at legislative history, and maybe that gives us some guide, but we have to construe the statutes as they're before us. And Vera No was a minor child, a living, heart-beating, breathing in the end, minor child. Judge, I'm going to close with how I began. And I want to say that, and this is in anticipation of what the defense is going to argue, that this is not an indictment of midwifery in Nebraska or anywhere. This isn't about what the law ought to be, that somehow if the law was different, it would have made it easier for Ms. Hock to be licensed, to be trained. I don't know. It's not what the law ought to be. It's not for the state to decide that, and it's not for this court to decide that. You're here for the purpose of deciding whether this act fits the criminal code under the negligent child abuse resulting in death. And this is certainly not the defendant's place to decide what the law for midwives should be. This case is not the mountain for midwifery to die on. Mothers have the right to decide to handle how they birth their children. No question. It's clear by the law. Doesn't matter what my opinion is on that. It doesn't matter what this court's opinion is on that. It doesn't matter what the defense counsel's opinions on that. They have a right to make that decision. No question. But had Angee Hock had a legitimate conversation explaining the pros and cons of a vaginal breech delivery, as she promised she would do when they hired her and when they paid her to do this, and when they signed their contract and they were made promises, this is what I'm going to do for you. I'm going to help you through this. I'm going to give you advice. And they believed her. And had she done all those things, and the nose said, you know what, Angee, I trust you. I appreciate you telling us all that. We're going to still try to do this alone at home. This wouldn't be a crime. I think we all know that. It would have still been sad and tragic, but it would not have been a crime. A good midwife, licensed or not, would not have acted like she can handle a breech delivery. and spent 2 to 3 minutes talking to a young, vulnerable mother to make that kind of life or death decision. This was negligence. This was reckless. I'm asking this court to find her guilty.
Mr. Dorn, before you proceed, we're going to take a couple seconds, let court reporter stretch.
Sounds good, Judge.
You ready? Okay. Go ahead, Mr. Dorn.
Thank you, Your Honor. The death of Vera No was a tragic accident due to complications of childbirth. Vera No was a loved baby whose parents eagerly anticipated her arrival, and they did their very best to help her come into this world safely. When Vera's birth became a medical emergency, everyone involved did the best they could with the resources available to them at that time, and they all tried to save her life. That included Angela Hock, who utilized all of her midwifery skills and training to try to save Vera's life, just as a doctor or a nurse midwife would have done at a hospital. Through this action, the state is attempting to scapegoat Angela Hock by holding her responsible for the circumstances and the policy decisions that impacted Vera No's birth and death. Those were entirely outside of Angela Hock's control. Your Honor, Angela Hock can only be convicted if the state proves every element of the charge that they have pursued against her, in this case, beyond a reasonable doubt. And Your Honor, the state has suggested that there is a lesser included offense in this case. That is not true. Angela Hock was specifically charged with negligent child abuse resulting in death. The structure of the child abuse statute asks the finder of fact to compare the mental state of the defendant with the magnitude of the harm. The state could have charged Mrs. Hock with intentional child abuse. They could have charged her with negligent child abuse resulting in serious injury. They could have charged her with negligent child abuse resulting in no injury. They did not charge her with that. And I would ask you to look at the information that they presented, because that is what is on that document. And a lesser included instruction is not possible in this case. Your Honor, over the last 3 days, the state has failed to prove a single element of the charge against Mrs. Hock. And for that reason, we ask the court to find her not guilty of the crime of negligent child abuse resulting in death. The evidence has disproven the original assertion of Dr. Lessman to the police, which was that Angela had acted negligently and that Vera's death was totally preventable if she had sought medical care. First of all, Your Honor, death in childbirth is not totally preventable. The states acknowledge that. The doctors have testified to that. It is not possible to totally prevent the possibility of death. Period. The court learned that Emily No had a history of serious trauma related to hospital-based care, and that her decision-making for childbirth was strongly guided by her desire to avoid hospitals so that she would not be re-traumatized. Dr. Ophoven testified that the consideration of the risks to Emily No's mental health of postpartum trauma was a legitimate issue of medical concern. This was a risk that Emily No had the right to weigh in the balance when she made her medical decisions. Although Emily does not like to talk about the hospital experiences that caused her trauma, Creighton No's testimony made it clear that those experiences, including the way she was treated at Bellevue Hospital during the delivery of Sabra No, involved violations of her right to consent. For both Sabra and Vera No's pregnancies, Creighton and Emily explored many options for supporting childbirth, including with obstetricians at hospitals, midwife-led birth clinics, and home births attended by traditional unlicensed midwife in both Nebraska and Kansas. The state has characterized Emily No as some type of weak-willed woman, and that Angela Hock was an the Pied Piper of midwives, and Emily No was incapable of resisting her call. That's not what the evidence shows. The evidence showed that Emily No did a lot of homework on this issue. She consulted with a lot of people, and she traveled all around the Midwest. She knew exactly what she was doing. She wasn't tricked or coerced by Angela Hock in any respect. The No's were willing to drive 3 to 5 hours to visit with some traditional midwives. Creighton No also testified that the obstetrician that Emily No considered for Vera's birth told her that the only option she would support for the delivery of Vera was a cesarean section. That was the understanding of the No's. That understanding was in spite of the fact that Dr. McBee counseled them that a decision to do a home birth was just a normal medical decision. Creighton No testified that all options were on the table. But when it came down to brass tacks, Your Honor, Dr. McBee wanted to schedule a C-section. This is the type of coercion that happens to women in a hospital setting. Sure, ostensibly, the hospital will do whatever they want. If they want a vaginal delivery, that's their choice. But when it comes down to it, the option Emily was given was schedule a C-section. But regardless of how Emily took that conversation, the testimony was that vaginal birth was a reasonable option for her to consider, that that's how the obstetricians framed it, and that there were risks on both sides of the choice, vaginal birth or cesarean. The testimony of Creighton No and the recorded interview of Emily No made it very clear that they hired Angela Hock for traditional midwifery services in childbirth for the primary, specific reason that they believed Mrs. Hock was the provider most likely to respect Emily No's right to informed consent. Emily No told Detective Reisinger that Mrs. Hock, and I quote, is as involved as you want her to be, and that Mrs. No preferred, I quote, hands-off, unassisted approach to childhood. That was her choice. In her recorded interview with Officer Crouch, she said that she preferred home birth because it involved no checks. The No's and Mickey Heffley, who witnessed Emily's labors with both Sabre and Vera, testified that it was very important to Vera that nobody touch her without permission, and that Emily No did not allow a vaginal examination until she asked for one because she thought, and she would ask for one when she thought something felt funny. Emily No reported to Officer Crouch that Mrs. Hock never pushes anything, and that even in her at-home labor with Mrs. Hock for Sabre's delivery, she had shared with Mrs. No the reasons why she might consider going to the hospital at the point that fetal distress was discovered, and that Angela Hock supported Mrs. No in making her own decisions about what she wanted to do. And at that point, Mrs. No, Emily No, made the decision herself to transfer to the hospital. When the No's hired Mrs. Hock, they reviewed her agreement for services carefully. They signed it in her office. The agreement acknowledged that Mrs. Hock was unlicensed and uncertified. It stated that the No's took full responsibility for their decision to give birth at home with an unlicensed midwife. It stated that the Hocks were entering into this agreement with full knowledge that there were risks that came with this medical decision and that Mrs. Hock could not guarantee a positive outcome for the birth. The agreement explicitly stated that Mrs. Hock would never make a decision for the No's, but would support them in their own medical decisions. The No's entered into this agreement, and they planned for a home birth with the intention of bringing a healthy baby into this world. The documents they signed were very similar to the consent documents they would have signed for medical decisions, for any medical decisions that hold risks. All of the evidence before the court in this trial has demonstrated that childbirth is a risky process and that women face risks on all sides of their decisions. And they have to weigh those risks according to their own values and their own experiences. Creighton testified that Dr. McBee's ultimatum that she could either have a cesarean at the hospital or find somewhere else to go caused Emily to panic. Emily panicked because she did not want to receive hospital-based care. For that reason, in the last trimester of her pregnancy, she did not receive hospital-based prenatal care or ultrasounds. The Noes were aware of the possibility of ultrasounds, and Emily reported to Officer Crouch that she had in fact received some early ultrasounds from Stork Vision just for fun. However, the Noes did not choose to receive a late pregnancy ultrasound to check the position of their baby. The fact that her baby was in the breech position at the time of delivery was therefore a complete surprise that was discovered during labor. Nobody disputes that Emily Noes' labor with Vera was going normally until she consented to a vaginal exam from Angela Hock, at which time Mrs. Hock felt that the presenting part at Emily's cervix, which is several inches above the opening to the vagina, was not ahead. The testimony of Mickey Huffle was that she overheard Mrs. Hock muse to herself as she's reaching up into the vaginal cavity, possibly a cord. Oh, a foot. What she realized at that moment was that this baby was presenting in either a footling breech presentation or a complete breech position. Dr. Lessman and Dr. Ophoven tested that a footling breech presentation is more likely in premature babies who are small enough to extend their legs in utero. Vera Noe was a full-size baby at term, making it more likely that the baby's legs were bent, but that the foot was presenting next to the buttocks in a complete breech position. At that time, Creighton Noe testified and Emily Noe reported to officers that Angela Hock had a conversation with the Noes about their finding. That conversation concerned their option. She informed them that their baby was presenting in the breech position and that the breech position carries more risk than the head down or vertex position. The state has presented no evidence on what specific risks were discussed in that conversation. What the state has said is that you couldn't possibly communicate those risks in 2 or 3 minutes. 2 or 3 minutes is a long time, Judge. There's a clock right over here. If I were to tell you, Your Honor, the baby's in breech position, you have the option to transfer to a hospital, or you can stay here, I have training in breech birth. That took about 5 seconds, Your Honor. I'm perfectly willing to give up 30 more seconds of my closing so that we can demonstrate exactly how long of a time this is. Your Honor, the state's position is that risk couldn't be communicated in this time period. We're 30 seconds in. Your Honor, that was 1 minute. That's a lot of time to talk. I've talked a lot in the space of 2 or 3 minutes. Ms. Jacobson can talk a lot in the space of 2 or 3 minutes. The evidence was that they had a 2 or 3 minute conversation. Creighton Noe stood up here and testified that after 3 years, he couldn't remember exactly how long it was or what was discussed. The state has not proved beyond a reasonable doubt that the risks weren't discussed. The evidence shows that there was a time period of sufficient time for that conversation to take place. That conversation did take place, and Emily and Creighton Noe made their decision based on that conversation. Importantly, Your Honor, the standard isn't that the standard of informed consent for medical providers is not that you inform them of every specific risk. Dr. Lessman and Dr. Ophoven acknowledged that even for licensed healthcare professionals, Informed consent conversations involve discussions of general risks rather than specific depictions of everything that can go wrong in each scenario. The Noes both reported that Angela stated that she was willing to support them in their decision to stay home or to go to the hospital. That was because of her commitment to supporting Emily No in her decisions, and because she did have training in natural vaginal birth delivery. That training was listed on her agreement, and those certificates, some of those certificates, have been shown as exhibits in this court. Testified that they had a private conversation between Creighton and Emily about what they wanted to do. Based on that conversation, they decided to stay home and see if the baby could be born naturally. The evidence indicates that Emily No continued to labor through contractions. Emily and Creighton No testified that Emily told Creighton before she went into the bathroom that she was ready to accept a hospital transfer and that he was packing a bag to go. But Emily said she had to use the bathroom. She told Officer Crouch that Angela asked her if she needed assistance before she entered that bathroom. Emily declined that offer. Emily reported to Officer Crouch that Angela warned her that her bathroom urge could mean the baby was coming. Emily reassured everybody that she was fine and that she wanted to use the bathroom privately. She then went into the bathroom and closed the door. She was in there for about 15 minutes. There was no sounds coming out at that time, but Creighton asked her through the door at least once whether everything was okay. She responded that it was. During this time period, Mrs. Hock nursed her baby in the guest room. The doula was in the guest room. Everybody was within close earshot and close proximity to that bathroom door. When Emily called out suddenly for Angee, everyone moved to the door. Angee handed her baby to Mickey. The testimony of Creighton No and Mickey Heffley is that as soon as that door opened, they could all see that Emily was leaning over the bathtub with Vera hanging out of her to the chest. The testimony is that Angee immediately stepped in to help, and she immediately directed that 911 be called. Mickey handed Angee's baby to Creighton. She picked up her phone and dialed 911. Then she handed the phone to Creighton to talk to the dispatcher while Mickey stepped in to assist. Creighton then went downstairs. Now, what happened next demonstrates the fallacy of the state's argument that Angela Hock is completely untrained and not capable of assisting in this birth. Because the steps that Angela Hock took over the subsequent minutes were the exact steps that Dr. Catherine Lessman testified that she would have taken. If Dr. Lessman was walking by the street and came by this house and they called out, "Help, help," and she went up those steps to assist, she would have done the exact same thing that Angee Hock did. Dr. Lessman testified that there are certain tools that are within the exclusive purview of hospital-based care, such as forceps or surgical delivery. They didn't have those tools. Even though Dr. Lessman testified that she would have taken the same steps that Mr. Hock took on the basis of her doctor's training in breech delivery, even though she had never seen a vaginal breech birth, and that she would have done the same thing that Hock did to respond to this emergency and try to save Vera. Dr. Lessman testified that the first thing she would have done to extract the baby was to get the baby's stuck arms reduced to bring them down. Dr. Lessman testified, Emily No told Officer Crouch that that was the first thing Mrs. Hock did. She assisted in getting Vera's arms and shoulders out. Dr. Lessman testified that she would have put Emily into different positions that would help her pelvis to open and to release the baby's trapped head. Those included putting her on her back with her knees bent and putting her on her hands and knees. Mickey Heffley testified that Mrs. Hock had her help Emily get into both of these positions, and that Emily chose to cooperate with these efforts to get Vera delivered. The EMTs testified that when they arrived at the Nose home, they found Emily on her hands and knees in the hallway, with Mrs. Hock supporting Vera's body while she tried to free the stuck head. The EMT's testimony was that they were unprepared for the situation and that they panicked. They arrived, as Ms. Jacobson pointed out, the first thought through one of their heads was, oh crap. They knew when they were on the way that what they should do is immediately transport Emily No. But when they got there, they hesitated. They were unable to perform even the very basic maneuver that they learned for childbirth to insert their fingers into the vagina to make space for the baby to breathe. Captain Hurd, who by his testimony was the one delivering care, specifically the one at Emily's side holding the baby while he delivered care. And his testimony was that the perineum was sealed so tightly around Vera that he couldn't even insert a finger. The 911 responders looked to Mrs. Hock to get the baby delivered before transfer. As Emily reported to Officer Crouch, and I quote, "They obviously didn't have proper training for this type of situation, nor did they have proper equipment." Dr. Lessman testified that if she were unable to free a baby's head because the perineum was too tight to manipulate it, her next option would be to cut an episiotomy to make more room for the hands. Emily No told Officer Crouch that the reason Angela Hock attempted the episiotomy was to make more room for her hands to free the baby's head. The appropriate tool for an episiotomy is surgical scissors. Paramedic Carroll testified that he had a trauma kit with surgical scissors in it, but that he didn't offer it to Mrs. Hock. What they offered her was a choice between a scalpel and trauma shears. Dr. Lessman testified that given that same choice between scalpel and trauma shears, that in that situation, she would have chosen the trauma shears for the episiotomy to reduce risk of harm to the baby. Even the doula, Mickey Heffley, testified that the use of a scalpel would have posed a serious risk of cutting the baby's necks. The EMT responders did not understand enough about childbirth to know that when they offered Mrs. Hock a scalpel. Unfortunately, trauma shears were ineffective for the task. Mrs. Hock cut Mrs. No's skin with a first-degree laceration, but was unable to hack through the muscles with those trauma shears. During this time, the EMTs wasted precious moments. Mrs. Heffley testified that she heard Mrs. Hock direct the EMTs that they needed to transport Mrs. No immediately. Finally, Emily No was loaded into an ambulance, and Vera was still inside her. This situation was an extreme childbirth emergency. Vera's head entrapment meant that she was at a serious risk for cord compression and oxygen loss. Although Dr. Offman testified that we cannot know whether and when her cord was compressed during the emergency, or if it was compressed during the entire period of her head entrapment. Dr. Lessman specifically testified that even in situations of cord prolapse outside the hospital, babies usually survive. She testified they have a 60% chance of survival. Nevertheless, Vera needed to get delivered quickly, and she was very likely to require resuscitation. The EMTs arrived at the house at 9:30 p.m. Their report indicates that they left the house at 9:40. They arrived at the hospital at 9:59. Road construction issues outside the EMT's control significantly delayed their arrival. This 3-mile drive should have taken 9 minutes. It took 19. The ambulance report described this as a slight delay, but from the perspective of Vera No's survival, this was an extreme delay. Vera's medical records and her ultimate autopsy report show that Vera was delivered in the ambulance at 9:48 p.m., a time that the hospital-based providers would have received from the EMTs when they transferred Vera's care to them. The EMTs reported that Vera had good color when she was born, but that her color turned blue as the ambulance went on. Dr. Ophoven testified that the fact that Vera's color was good at birth indicates that she might have been able to survive her difficult delivery if she had effective neonatal resuscitation from trained providers. Unfortunately for everybody in that ambulance, the responders had not been provided with that training. They were unfamiliar with a neonate's respiratory rate. I asked both paramedics about this. They gave 2 answers. Both of those answers were different than the expert testimony of Dr. Ophoven. They did not possess the correct equipment, an issue I will return to. They failed to suction her mouth to clear her airway. They didn't have the mask they use. They were unable to get a tight seal around her face. Because her airway wasn't open and because there was no tight seal, they couldn't get air into her lungs. They also did not have epinephrine or know how to use it to restart her heart, as doctors Ophoven and Lessman said would have been essential in this situation. Because the baby wasn't properly oxygenated, her condition significantly declined between her birth and her transfer to the NICU team. Doctors Bone and Ophoven testified that a neonate without oxygen for 11 minutes, or even a few minutes after delivery, would have a severely compromised likelihood of survival. Emily declined the EMT's offer of an IV in the ambulance, telling them even in that situation that she had PTSD and needed them to heed that in her care. By the time Vera arrived at the hospital, her brain had suffered serious injury from loss of oxygen, and she was unable to survive without life support. The state asked you to find Angela Hock criminally responsible. And what they have to prove is that she caused the death of a minor child by causing or permitting her to be placed in any of the dangerous circumstances that Vera faced during this process. I'm going to address these elements one by one, starting with the assertion that Mrs. Hock caused the death of a minor child. Before I continue, I want to be very clear about something. Everyone in the situation valued Vera's life and wanted her to be born safe and healthy. This argument about the definition of a child is a technical, legal argument, but a very important one. The state of Nebraska enacted a statutory scheme to protect unborn children. They did that because the life of an unborn child is valued. And I want to address Ms. Jacobson's argument on the motion to dismiss. She gave a hypothetical situation where a person stabs a pregnant woman and her unborn child dies as a result, or unborn child is born and then dies later as a result. Under those facts, that person could be charged under the Homicide of an Unborn Child Act. There's no question about it. Angela Hock could not be charged under that act based on the facts of this case, and specifically the fact that she was rendering aid to a mother in childbirth. And the reason she could not be charged under the Homicide of an Unborn Child Act is because the Nebraska legislature considered a situation like this, and they carved out several exceptions. The Homicide for an Unborn Child Act specifically excludes from prosecution, and I quote, an act or conduct causing or contributing to the death of an unborn child when the act is 1, committed or engaged by the mother of the unborn child, or any medical procedure performed with the consent of the mother. Neither Mrs. Hock nor Emily could be charged under the Homicide of an Unborn Child Act based on this carve-out. The Nebraska legislature made this carve-out to protect mothers giving birth and those that assist them. In fact, the Nebraska legislature considered whether the second carve-out about a medical procedure should apply only to licensed practitioners. Early drafts of the bill included that language, but it was amended to take out any mention of licensed practitioner. That demonstrates that the legislature intended to protect people like Mrs. Hock who assists with childbirth, despite not being licensed. Now, the state has advanced its own theory about when an unborn child becomes a child. They have offered no support for that theory. They invented this definition. There's no basis in law whatsoever. It is the province of the legislature to make the law, and the statutory scheme enacted by Nebraska is based on the proposition that goes all the way back to the foundations of our law, that a child is not legally a child until it is fully born. And in the context of what is a child and what is an unborn child, it is the height of logic for the legislator to provide an exact moment when that transition occurs. The law requires tightly defined terms. The law required the legislator to make a choice about what specific point an unborn child becomes a child. The definition cannot be imprecise. It cannot be imprecise because it could be unconstitutionally vague. If it was imprecise, how would we know when to apply this law? The state is trying to invent a new law with this charge. Now, when the Nebraska legislature considered this exact issue in the Pain-Capable Unborn Child Protection Act, they enacted the following law, which I will read. Granted, this is in the context of abortion, Judge, but it demonstrates the legislature's understanding. When, as the result of an abortion, a child is, in the sound medical judgment of the attending physician, born alive, then all reasonable steps in accordance with the sound medical judgment of the attending physician shall be employed to preserve the life of the child. For purposes of this section, born alive shall mean the complete expulsion or extraction of the child from the mother, irrespective of the duration of the pregnancy. And after such expulsion or extraction, such child breathes or shows any other evidence of life, such as the beating of the heart, the pulsation of the umbilical cord, or definite movement of voluntary muscles, whether or not the umbilical cord has been cut or the placenta is attached. The legislature never felt the need to revisit the minor child language because since at least 1951, it has been crystal clear in Nebraska that a child means a living, breathing child outside of the mother's body. The child abuse statute has been amended many times since the legislature provided protection for unborn children. Each of those times was an opportunity to change this law. It was amended in 2006, 2010, 2012, 2013, 2015, and 2019. If the Nebraska legislature intended child abuse to apply to situations like this, it would have said so. Your Honor, childbirth killed Vera No. Being born is dangerous. It's dangerous for the baby and the mother. No matter where Vera was, the risk of death remained. A great trial attorney and a mentor used to close with the question, why are we here? It's a very good question. And the answer has to do with everything I just talked about. The state could have charged her with the practice of midwifery without a license. They didn't charge her with that because they want blood. And for all the reasons I just went over, they knew that they couldn't charge her with manslaughter of an unborn child, so the state invented a new crime. And they did that because they wanted a scapegoat, and they want to sacrifice that scapegoat publicly, and that's why we're here. I'd like to address the element of dangerous situation. What exactly is the dangerous situation that the state accuses Angela Hock of placing Vera No? At all times relevant to Angee, Vera No was contained inside the body of a fully capable adult who made all decisions about where to place Vera through deciding where to place her own pregnant body. Did Angela Hock place Vera No in the dangerous circumstance of childbirth? No one is in control of the dangers that can arise during that time. All the doctors have testified that childbirth is an unavoidably dangerous situation for the mother, even more so for the child. Angela Hock did not place Vera No in the situation of having to be born. Did Angela Hock place or permit Vera No to be in the dangerous situation of planned home birth? The state has not even come close to proving beyond a reasonable doubt that there was an unjustifiable risk of death in planned home birth. The evidence is that both Creighton and Emily were determined to give birth outside of the hospital. They discussed home birth outside of a hospital with obstetricians at Offutt before both Sabra and Vera's births. Emily's obstetrician did not treat home birth as a substantial and unjustifiable risk. They treated home birth as just another medical option. In her last checkup with Dr. McBee, Emily was told that she had a normal pregnancy and that Dr. McBee did not anticipate any complications, but that obviously risks still remained. But when it came down to brass tacks, Dr. McBee wanted to schedule a C-section, and that indicated to the nose that they would need to go elsewhere if they didn't want a surgical delivery. Dr. Lessmans and Ophoven testified that there are risks to planned surgery just as there are risks to planned home birth, including an increased risk of death to the mother, the baby, and to future pregnancies from cesarean surgery. Dr. Creighton testified that the nose planned a large family. Both Drs. Lessman and Ophoven acknowledged that the risk to Emily and her baby would rise significantly with each cesarean, so that it was very reasonable for Emily to want to avoid a surgical delivery if possible for the birth of her second child. Emily told law enforcement that she didn't want another surgery. Dr. Lessman testified that that was Emily's right to choose. Emily didn't think she could have labor in a hospital because she anticipated panic attacks and trauma. Emily was going to have birth outside of a hospital. The only options available to her in Nebraska were home birth with an unlicensed traditional midwife or a home birth unassisted by anyone. Emily carefully researched her options. She talked to the obstetricians. She had ultrasounds done. The evidence shows that Emily educated herself and made her own decision. A pregnant mother has the right to weigh those risks and benefits and to weigh the various options in deciding when to give birth. Emily made the decision to give birth to her child Vera at home. She made this decision both before and after the discovery of breech. She and Creighton have always taken responsibility for the decisions that they made throughout this matter. At no time have they blamed those decisions on Mrs. Hock or suggested that Mrs. Hock tricked or led them into those decisions. The circumstance that placed Vera in a situation that endangered her life was childbirth. One complication of childbirth is head entrapment. Evidence shows that Emily was well aware of those risks. Now, there's been a lot of talk about a prolapse cord, Your Honor, and I want to address that. There has been very little evidence about a prolapse cord. As I said earlier, the only witness that talked about a cord was Mickey. Mickey didn't see the cord. She wasn't close to the examination. She wasn't privy to the conversations between Emily, Creighton, and Angee. And what Mickey says was that she heard Angela muse to herself, possibly a cord? Oh, toes. There's a very simple and logical explanation for that. Mrs. Hock thought she found a cord, but then realized it was actually toes. During the vaginal exam when this was discovered, the cervix was dilated, but no part of Vera had passed through the cervix. When Angee reached up inside and felt around, she discovered toes. That is the only evidence suggesting in any way that there was a cord prolapse at that time. Nobody else says that's what happened. Emily doesn't say it, Creighton doesn't say it, and Dr. Lessman's testimony offers circumstantial evidence that it was not, in fact, a cord prolapse at that time. Dr. Lessman testified that if the cord were pinched, you have a matter of minutes before fetal death. It was at least 30 minutes, maybe as long as an hour after this examination before this baby was born up to her chest. But Vera had good color until after she was born. That was the paramedic testimony. Paramedic Heard, who was closest to the baby, who was holding the baby, said she had good color. If the cord was prolapsed, that would not be the case. And finally, Emily placed herself in that bathroom She refused offers of company. Emily No closed the door. The beginning of the birth of Vera No happened in the 15-minute period when Emily No was in the bathroom alone. The state has presented no evidence about what occurred in the bathroom over that 15-minute period. And to this day, we do not know exactly how the situation went from Emily saying everything's okay to all of a sudden the baby is hanging out of her to the chest. Importantly, we don't know whether the child was pushed out of the mother's body through contractions or whether the baby was pulled out by Emily No. Dr. Lessman testified that sometimes mothers do that. She testified that if someone pulls on a breech baby in the process of emerging, then the baby can become stuck in exactly the way that Vera was. What Emily told police, and the only thing we know about this, is that she was sitting on the toilet, felt the urge to push, and then the legs and stomach presented quickly. There is doubt as to what actually occurred in that bathroom. Turning to recklessly, Your Honor, you asked me about the law-abiding citizen language during the motion to dismiss, and I'd like to read the entire definition of reckless to demonstrate what a complicated proposition it is. Reckless shall mean acting with respect to a material element of an offense when any person disregards a substantial and unjustifiable risk that the material element exists or will result from her conduct. The risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to the actor, its disregard involves a gross deviation from the standard of care that a law-abiding person would observe in the actor's situation. It's important to note that the only legal prohibition against attending a home birth specifically prohibits a licensed certified nurse midwife from attending a birth in any location other than a hospital setting. There is no law in the state of Nebraska that prevents parents from giving birth at home or for anyone else to attend that birth. The proper interpretation of reckless must read the phrase, considering the nature and purpose of the actor's conduct, together with the phrase, gross deviation from the standard of conduct that a law-abiding person would observe. Those phrases are in the same sentence, and the first clause qualifies the second. The analysis of whether Angela acted recklessly is more nuanced than simply determining that, since she may have been breaking the law of practicing midwifery without a license, that she must be reckless. The analysis must take into account the nature and purpose of the actor's conduct, which in this case was to assist at a home birth. Therefore, the proper question to ask is, what would a law-abiding person who has chosen to assist in childbirth do in this situation? Considering the fact that Emily was determined to give birth at home and that Angee agreed to assist her with that, and taking into account what was known to Angela, it was not a gross deviation of the standard of conduct that a law-abiding person would observe to act as Angela did. If Angela didn't provide care, there was a real possibility that Emily would attempt a home birth unassisted. That would have been reckless. The state has not proven that Angela was reckless with respect to the possibility of Vera's death. The evidence shows that Angela received training on childbirth and specifically on breech birth. The evidence shows that Angela acted consistently with what Dr. Lessman would have done if confronted with this exact situation. If Angee's training in breech and training in midwifery had been a hoax, as the state seems to suggest, she would have not have known how to do, step by step, the exact same things that Dr. Lessman learned how to do in her own training. Dr. Lessman testified on the ethical support of medical decision-making. She testified that there are standards of care that apply to licensed health professionals. Her testimony shows that Angela acted ethically in supporting Emily's decision about how to proceed with Vera's birth. The American College of Obstetricians and Gynecologists reported the best evidence in 2008 that a vaginal breech birth may increase the risk of neonatal mortality and morbidity relative to a surgical delivery, but that then again, it may not. Dr. Ophoven testified that most vaginal breech births turn out fine, and that any relative increase in risk is happening in the single-digit percentages. That doesn't meet the standard of proof of beyond a reasonable doubt that the choice for vaginal breech birth at home recklessly ignored a likelihood of death. The state wants you to believe that this was a death sentence, but that was not the expert opinion or evidence before this court. The state is trying to conflate civil negligence with criminal negligence, Your Honor. They are not the same. The type of civil negligence standard that would hold an OBGYN accountable for the death of a child is not the proper standard in this case. Dr. Lessman made clear in her testimony that when she told the police that Angela Hock was negligent, she was referring to professional negligence under the standards of care of the American College of OBGYNs and the American College of Nurse Midwives. She also testified that she would not expect those standards to apply to a traditional midwife, or for a traditional midwife to be familiar with those standards. Dr. Lessman testified that she has no knowledge or awareness of the standards of care that apply to traditional midwives attending home births. Dr. Lessman's assertion that Mrs. Hock was negligent was legally meaningless, and yet it led to the conflation of professional negligence with criminal negligence, and it led directly to the initiation of this action. Your Honor, I want to talk about the element caused or permitted. When Emily is carrying Vera in utero, Emily is in complete control of causing or permitting anything that involves her pregnancy and the placement of Vera No. This is a sacred right and responsibility. It rests solely on the shoulders of Emily No. Emily No is in control of her body, her baby, and her birth. Emily No is autonomous, she's independent, and she possesses free will. She never stopped exercising that free will during the entire pregnancy with Vera No. All of this demonstrates that Emily was a powerful advocate for herself. Creighton No testified that the Noes were aware at all times that presenting at the hospital for care was an option. The Noes were also aware that Angela Hock would have supported them at any time in their decision to transfer. Angee never suggested that they avoid the hospital. Emily No declared that home birth was how she was going to handle Vera's birth, and she never wavered. There is no testimony from the parents that Mrs. Hock made any decisions for them at any time. And the parents chose Miss Hock for exactly that reason, because she was the most likely to respect Emily's decisions. In fact, Angela provided information to the parents during both births, and Emily always made the final decision. This is supported by Emily No's interview with Lisa Crouch. When Angela determined that Vera was presenting breech, Emily says she gave her options: transfer now or continue with the home birth. Another 2 to 3 minutes of conversation ensued. Angela accurately and honestly told Emily that she was trained in breech. Dr. Lessman's testimony was that even after the diagnosis of breech, you can typically expect hours more of labor. She testified that the identification of breech, absent other signs of fetal distress, was not an urgent emergency situation. Therefore, it was not an unjustifiable or substantial risk to continue labor at home. Emily No was a strong decision maker. She was determined to avoid hospitals. She exercised her own medical decision making. Even in the ambulance, she exercised her own medical decision making when she refused an IV. At that time, Emily and Vera were still connected by the umbilical cord. By refusing the IV, Emily could have been refusing life-saving medicine for Vera. That was her decision. The only way Angela Hock could even have indirect control over where Vera No was placed would be if she had control over Emily No. The only person that controlled Emily was Emily. The proximate cause of death, Your Honor, there is a mountain of reasonable doubt as to what the proximate cause of Vera No's death was. In order to establish that Angela's unlawful conduct was a proximate cause of Vera's death, the state is required to prove beyond a reasonable doubt that but for Angela's actions, Vera would have survived childbirth. Your Honor, I didn't make that line up. That line came from a case, State versus Murrow. In that case, that is the language they use. Would have survived. What the state has proven is the possibility of survival. That is insufficient. The evidence that creates reasonable doubt is as follows. First off, the immediate cause of death agreed on by 2 pathologists was cerebral anoxia. Both the pathologists testified that this was an accidental death. Dr. Ophoven went so far as to consider classifying it as a natural death because deaths happen in childbirth. You cannot eliminate the risk. And I'm going to quote from a definition of proximate cause, Your Honor. The act or omission to act is the proximate cause of death when it substantially and materially contributes in a natural and continuous sequence unbroken by an efficient intervening cause resulting in death. Similar to Murrow, here the state has not proved that Vera would have lived but for Angela's actions. And the reason they can't prove that is because there are many intervening causes that break the chain of causation. The first is the bathroom, Your Honor. There is a black hole of doubt created by our inability to know what happened in that bathroom when Emily went inside. Emily told law enforcement that about 30 minutes after Angela performed the vaginal check, she had bathroom needs. She said she went into the bathroom, she felt an urge to push. At that point, she could have called for assistance. She did not do so. If she had, then Angela may have been able to perform maneuvers she learned during her training to prevent head entrapment. We know that Clayton called through the door to check if Emily was okay, and she reassured him he was. Emily chose to push on her own in private during those 15 minutes. That is an intervening cause. Another intervening cause, Your Honor, involves the EMTs. Now, it gives me no joy to beat up on the EMTs. I have a lot of respect for the EMS personnel who testified. I used to be an EMT, and I know that they have an incredibly hard and thankless job. And unfortunately, they were not trained for this type of situation. And Your Honor, when the four EMS personnel came in, they offered inconsistent testimony. There's no way around that. Some of it can be chalked up to the passage of time. Some of it was clearly an effort to protect themselves. The evidence shows that the emergency personnel were scared. This is the worst case scenario for EMS in an ambulance. They don't want any part of this because they're not trained to handle it. They testified that there are almost no interventions they can give. The only interventions they're trained to give are the V maneuver and then suctioning the airway in order to resuscitate. That's why their protocols are load and go. They're supposed to show up, load that patient, and get him to the hospital as soon as possible. Instead, they showed up, thought, oh crap, and they waited. The testimony by Mickey Huffle is consistent with that. Mickey Huffle testified that when they showed up, they did not have proper sense of urgency. The testimony was that Angela asked for scissors. All the EMS personnel testified that they had an idea that she was going to attempt an episiotomy. The medics incorrectly surmised that the proper tool to do this was a scalpel. Dr. Lessman refuted that. Paramedic Carroll testified that the trauma box was brought into the hallway. He testified that a trauma box would contain surgical scissors. He was not able to answer why those scissors weren't provided. EMS offered Angela a choice between a scalpel and trauma shears, and she made the right decision. If EMS had given Angela the surgical shears, she may have been able to save Vera by performing an episiotomy, which was called for at that time, according to Dr. Lessman. She did not have the proper tools. EMS was in that house for 9 minutes. They testified that they were confused about Angela Hock and who she was, and that's why they took that long to load and go. That's not what Mickey's testimony was. That's not what Emily said in a recorded conversation. What they said was that EMS stood around hoping that Angee would birth Vera. They were in that house for 9 minutes, Your Honor. Brian Strasdis testified that the attempted episiotomy took 1 to 2 minutes. Paramedic Carol testified that loading Angela onto the bot and taking her into the ambulance would take about 2 to 3 minutes. That means there's 4 to 6 minutes unaccounted for. Why didn't EMS load and go like their protocol directs? Why didn't EMS bring the bot immediately to the scene when they arrived, knowing that it was a breech birth, knowing that their protocols were to load and go? Is it because they were confused by Angela, or was it because they desperately hoped that Angela would deliver the baby on the scene and they would not have to provide care that they were untrained to do? The EMS records are also clear that the trip to the hospital took 19 minutes. The hospital records are clear that Vera was born at 21:48, 10 minutes into that ride. The paramedics testified that Vera was born when they turned onto Farnham from Saddle Creek, basically right by UNMC. But the hospital records and Emily's statements conflict with that. Emily stated that after Vera's birth, the EMTs attempted resuscitation. Emily said that the EMTs couldn't get a good mass seal. She said the EMTs didn't have the tools to cut or clamp the umbilical cord, and they debated amongst themselves what to do. It is unclear how all of this would have occurred if the ambulance was pulling into the hospital as Vera was born. The next facts are not disputed, Your Honor. EMS testified they had their OB kit with them. EMT Morrison testified that the only thing in that kit that could provide a life-saving intervention was the bulb. May I approach?
Mr. Stern, I also would let you know you have 5 minutes left of your hour allotted time for closing.
Your Honor, this is that bulb. Doesn't look like much, but this is a life-saving intervention. Your Honor, ABCs. Everyone with any type of medical cert learns ABCs: airway, breathing, compression. You cannot provide oxygen through an airway that is closed. Dr. Ophoven testified that a neonate's airway would be full of liquid. EMT Morrison said that this was not used. That explains why this baby was born with good color, and that despite resuscitation, that color deteriorated. The airway wasn't open, she wasn't being oxygenated. You learn the ABCs in a simple CPR certification, Your Honor. It's the first thing you're supposed to do when you assess a patient. They failed to do that. The paramedics gave different answers for the rate of resuscitation. Paramedic Hurd testified that he basically resuscitates a neonate the same as an older child. The answers given about neonate resuscitation were 100 to 140. Carol said 40 to 60. Dr. Ophoven says it's 20 to 30. They were not properly trained. Vera did not receive suction. She didn't receive epinephrine. She was not intubated. She did not receive the proper neonatal resuscitation that could have saved her life. Vera might have lived if she had received proper care in that ambulance. To sum it all up, the state has failed to prove beyond a reasonable doubt a single element of this charge. They failed to prove beyond a reasonable doubt that Vera was a minor child. They failed to prove that Angee acted recklessly as defined by the statute. They have failed to prove beyond a reasonable doubt that Angela Hock caused or permitted Vera to be placed in a situation that endangered her life. And they failed to prove beyond a reasonable doubt that Angela Hock's actions were the proximate cause of Vera's death. They have not proved that Vera would have lived but for Angee's actions. They have proved that it was possible that Vera would have survived. Your Honor, Vera No died tragically from a complication of childbirth. This was despite the best efforts of everyone to help her survive. There is no criminal liability in these facts. Thank you, Your Honor.
We'll take a 5-minute recess. We'll be in recess for 5 minutes before we commence with the state's rebuttal. Right? All right, we're back on the record. Ms. Jacobson, you may proceed with your rebuttal.
Thank you, Your Honor. I hope I'll be brief. Judge, the only scapegoat here is the one that the defense team and Angee Hock are desperately searching for in this case. I know this court can rely on the evidence in this case, and I hope you will go back and look at the transcripts to determine exactly what those EMTs said. No one was panicked. Nobody was scared. Sure, they were probably scared for the life of Vera No. They were doing the best they could. The EMTs weren't trained for a situation like this. They weren't trained for a situation like this because giving birth to a breech baby at home is very, very dangerous, and the No's didn't know that. Defense counsel said, when we're talking about the proximate cause issue, and what I will say is, it was the defendant's omission to act, did not do what she promised the No's she would do. There was toes, breech. She did not recognize the true risk, did not tell the No's head entrapment is a problem. Head was entrapped, cord pressure, caused anoxia, caused death. Both the pathologists say that. This was the proximate cause of that death. Defense counsel wants to say that Vera significantly declined during transfer to NICU. You heard the testimony. Blue, not breathing, no heart rate. That was the description of Vera in the ambulance right before they got to the ambulance bay. Dr. Lessman, purple, flaccid, floppy. Vera had declined as far as she could go. Vera, for all intents and purposes, was dead when she was born. Wasn't, because she did go on to live, but she didn't decline on her way to NICU. She was at the very end. Negligent standard. They're saying I'm conflating the negligence standard with the civil negligence standard. Angee Hock is the one that set the standard. The defendant set the standard when she said, Creighton and Emily, here's what I'm going to do for you. I'm going to guide you down the way to deliver birth. If something happens, I'm going to consult doctors if I need to. I'm going to do all the things necessary. I'm going to give you all the information so you can make an informed decision. Why are we here? Defense asked. We're here because Angela Hock committed a crime. The state needs to ensure mothers have a real chance of informed consent. Defense counsel said they have to weigh the risk, and breech was a complete surprise. Yes, it was. Then he goes on to argue that this informed consent is just talked in generalities. No, it isn't. When there's a breach identified, you don't talk in generalities. You talk about what we're facing here, and she did not do that. Defense is arguing that there was no evidence of what was said to them. It's because nothing was said to them. I asked Creighton, no. Did she talk about, did you hear the words prolax cord? No. Did you hear about head entrapment? No. And I asked a whole host of other questions. Did you hear this? Did you hear this? And he kept saying no, no, and he got more animated as he said it. If you heard about things, would you have gone to the hospital? Yes. Angela Hock put them in that situation. Angela Hock put Vera No at risk of causing death. And that's exactly what happened. Defense did a lot of theatrics. Let's look at the clock. Let's do 2 to 3 seconds. Look how much stuff could get spoken about in this 2 to 3 seconds. It took Dr. Lessman probably an hour just talking about those risks. I know it slowed down because it's a question and answer, which is the way it should be when you're talking about a life and death decision. 2 to 3 minutes isn't a very long time. How about we stop the clock for 5 minutes? The amount of time it took Vera to die. I'd ask you to find her guilty.
All right, I'm going to take the matter under advisement, and I'll announce my verdict tomorrow morning at 9 o'clock. At that time, between now and then, I will review the evidence and deliberate and make my findings and announce it at 9 o'clock tomorrow. Parties are excused. And can the defense, and I think it's just defense, get with my court reporter to make sure that she has all the exhibits you offered? Okay?